Friday, February 6, 6:47 a.m. Eastern, according to court filings. 4 U.S. Marshals arrived at Ivanka Trump's Miami residence on Star Island. They carried a court order demanding her passport. Within minutes, her legal team was on the phone. With the duty judge seeking an emergency stay, was denied. By 7:23 a.m., Ivanka had surrendered her passport. By that afternoon, a $15 million bond was posted, and GPS monitoring was active. The speed of these events wasn't accidental. It signaled the prosecutor's confidence and urgency. But headlines barely scratched the surface. The filing's 187 pages of dense legal documentation reveal a far more complex story. They detail financial transactions spanning multiple states, international shell companies, and wire transfers totaling tens of millions of dollars. The prosecution alleges these moves constitute money laundering, rooted through a network of LLCs that, on paper, had no real business purpose. Pages 43 and 89 of the filings show wire transfers totaling $84.7 million over a 20-month period, moving through entities in Delaware, Nevada, and even the Cayman Islands. The filings don't editorialize, they present evidence. One of the most striking details, Ivanka personally withdrew $3.2 million in cash equivalents across 14 months, never exceeding $9,500 per withdrawal. Under federal law, $10,000 triggers automatic reporting. These withdrawals fall just under that threshold, which prosecutors call structuring, and they interpret as deliberate intent. What turned this investigation from paperwork to personal scrutiny was Melania Trump's 2-hour testimony the day before the Marshals arrived. In a closed-door session, Melania answered 147 questions, took a single break, and notably declined to invoke the Fifth Amendment. Court documents cite her directly, including conversations where Ivanka allegedly instructed associates to keep it under 10, always under 10, referencing the $10,000 reporting rule. This testimony provided context that bank statements and wire transfers alone could not. Previously, investigators had documents, but no direct witness linking the numbers to intent. Melania's cooperation gave them that connection. The timeline is critical. Subpoenas issued months ago. Ivanka fought document production aggressively. Grand jury investigations expanded, and finally, Melania's voluntary testimony triggered immediate law enforcement action. By Friday, the case had escalated from a paper trail to human testimony, with Marshals acting before the weekend in legal terms. The combination of the evidence 31 wire transfers, offshore entities with no operations, structured withdrawals, and family witness testimony represents one of the most thoroughly documented financial cases involving a former White House official in recent history. This isn't a smoking gun story. It's a warehouse of evidence. Yet, the defense will argue, as they have, that legitimate business purposes, complex family finances, and absence of direct proof of intent create reasonable doubt. The documents themselves hint at both possibilities, a pattern consistent with laundering, and an interpretation consistent with high-volume business activity. The Marshals' visit wasn't just about the passport. By presenting the court order, enforcing compliance, and seizing travel documents, prosecutors sent a signal. The combination of Melania's testimony, the seized passport, and rapid bond proceedings marked a clear message. The federal authorities are serious. Ivanka's international travel connections, access to private aviation, and financial resources created concern for potential flight risk. But beyond headlines, the filings expose the intricate web that brought this case to a climax: a network of LLCs, repeated small cash withdrawals, and the rare cooperation of a family member willing to testify under oath. The financial picture in these filings is striking. Ivanka Trump's network of businesses spans 6 states and multiple international entities. including Delaware LLCs, Nevada companies, and Cayman Island subsidiaries. The prosecution's filings emphasize that some of these entities have no employees, no offices, and no revenue, yet they were recipients of substantial funds from Trump Organization accounts. Between March 2023 and November 2024, court documents show Ivanka signed 31 wire transfer authorizations totaling $84.7 million. The destinations were often shell companies with no apparent legitimate business purpose. Exhibit F, buried on page 147, offers one of the most specific pieces of evidence. $3.2 million withdrawn personally by Ivanka over 14 months, in amounts consistently below $10,000. This pattern, known as structuring, is explicitly cited in the filings. Structuring is not merely withdrawing cash, it's breaking up transactions to evade federal reporting requirements. Federal prosecutors argue that Ivanka's knowledge of federal regulations, stemming from her role as a senior White House advisor, made her fully aware of the law. In other words, intent is a critical element, and prosecutors believe they can prove it. Melania's testimony is central to this aspect. According to the filings, she witnessed conversations in which Ivanka discussed keeping transactions under reporting thresholds. This isn't a vague assertion, it's a direct, cited quote, "Keep it under 10. Always under 10. From a legal perspective, intent is everything in structuring cases. Mere withdrawals under $10,000 aren't automatically illegal. There must be proof the individual deliberately intended to evade reporting. Melania's account could provide that proof, giving prosecutors a human connection to otherwise abstract transactions. Yet the defense has countered aggressively. Ivanka's attorneys argue that all transfers had legitimate business purposes: licensing, deals, brand management contracts, and other international operations. They submitted 47 pages of supporting records, showing that money flowed because the business demanded it, not to circumvent the law. Furthermore, the defense challenges Melania's credibility, noting her financial and personal incentives. Family dynamics are messy, and the defense contends prosecutors may be leveraging those dynamics to build a case. Legal experts highlight the tension here. Former Assistant U.S. Attorney Daniel Goldman notes that family testimony is rare and powerful. Juries tend to pay attention when a close relative testifies about private conversations. On the other hand, structuring cases have historically been difficult to prove. Requiring more than patterns, they require clear evidence of deliberate intent. Harvard law professor Alan Dershowitz emphasizes that patterns alone aren't enough. The government must demonstrate the defendant knew the law and acted to evade it deliberately. This is where the case gains both momentum and complexity. The evidence is substantial, yet circumstantial in parts. Wire transfers, offshore accounts, and structured withdrawals provide a clear pattern. Melania's testimony supplies context. But the defense has legitimate explanations for the movements, questioning both intent and credibility. This is precisely why Friday's rapid escalation from testimony to Marshals at the door was so striking. The government sees a pattern of intent reinforced by a direct family witness, and the documents suggest they have the coordination to follow through beyond the Trump family. These filings highlight the broader implications for financial oversight. Cash-heavy businesses, real estate investors, and anyone structuring transactions near federal reporting thresholds should pay attention. The IRS has increased enforcement on structuring 340% since 2020. Ivanka's case may set a precedent that clarifies how intent is interpreted, especially in high-profile financial networks. The stakes extend far beyond a single individual. They reach into legal and financial norms nationwide. The real pivot in this case came not from documents or bank statements, but from a witness almost nobody expected: Melania Trump. According to court filings, Setti voluntarily appeared at a federal building in Washington for a closed-door 2-hour testimony. She answered 147 questions, took a single break, and notably did not invoke her Fifth Amendment rights. That combination of willingness and precision is rare in high-profile federal investigations, particularly when family members are involved. What makes her testimony so consequential is context. Until this point, investigators had wire transfers, offshore accounts, and cash withdrawals, but nothing explicitly tying these transactions to intent. Melania's testimony changes that. According to excerpts in the filings, she witnessed multiple conversations in which Ivanka allegedly discussed keeping transactions below the $10,000 reporting threshold. Direct quotes from the filing include, "Keep it under 10. Always under 10. Prosecutors view this as a clear statement of intent, directly connecting structured withdrawals to conscious knowledge of the law. The family dynamic here is unprecedented. In modern U.S. legal history, stepchildren are not afforded the same protections as spouses, and Melania wasn't compelled to testify, she agreed voluntarily. Courts and legal analysts have called this a rare window into private family communications, giving prosecutors insight into decisions that otherwise remain opaque. Her cooperation may have provided investigators not just evidence, but motive and internal perspective. Why Ivanka structured transactions, how decisions were made within the family business, and what she knew from her federal experience. At the same time, the defense is already pushing back. Ivanka's attorneys argue that Melania had personal and financial incentives to cooperate. Family tensions, public perception, and possible alignment with prosecutors' interests make her testimony potentially biased, the defense claims. In other words, while prosecutors call it a linchpin, the defense frames it as circumstantial. Colored by family politics rather than hard proof of wrongdoing, legal experts weigh in with caution. Former federal prosecutor Renato Mariotti calls family testimony incredibly powerful, while criminal defense attorney Caroline Policy notes that proving intent in structuring cases is notoriously difficult. Intent must be specific. The government can't rely solely on observed patterns of withdrawals. The jury, if it comes to trial, will have to parse whether conversations Melania recounted demonstrate deliberate law evasion or merely knowledge of complex business operations. Even beyond the courtroom, this testimony has sent ripples. The very act of one family member testifying against another is extraordinary, influencing not just legal strategy but public perception. It reframes the investigation from an abstract financial probe into a human story of internal observation, potential conflict, and decision-making. From a prosecutorial standpoint, this human lens strengthens the evidence narrative. From a defense perspective, it introduces questions about bias, motive, and credibility. Ultimately, Melania's testimony transformed what had been a paper-heavy investigation into a high-stakes, dynamic case. Friday's Marshals, the passport seizure, and bond proceedings were all a direct result of this shift. The law doesn't often get this intimate. Private family conversations rarely enter federal filings. Yet here, they are front and center, setting the stage for the legal battles to come. The aftermath of Friday's events didn't just involve passports and bonds. Within hours, prosecutors unsealed Exhibit G, 67 pages of communications, including emails, texts, and voice transcriptions. They then issued a rare order requiring Ivanka's legal team to surrender all business devices used since 2021, laptops, phones, cloud storage access. Compliance was set for Wednesday, February 11th, 4 days from the order. Former U.S. Attorney Barbara McQuaid called it extraordinary, noting that such requests are calculated, not reactive. The sequence is revealing. Thursday, Melania testifies. Friday morning, Marshals arrive, passport seized. Friday afternoon, exhibits unsealed. Friday evening, device surrender ordered. Prosecutors clearly anticipated the evidence flow. Melania's testimony provided context. But the devices may provide the corroboration or contradiction needed to make or break the case. Deleted messages, encrypted app communications, and internal discussions will all be examined. This is where theory meets verification, and the legal stakes rise sharply. Defense filings immediately followed. Ivanka's team challenged the passport seizure, the gag order, and the device surrender timeline. They argue that international travel restrictions, monitoring, and court-mandated compliance infringe on business operations and, they claim, constitutional rights. They continue to assert that the offshore entities had legitimate purposes, licensing, brand management, contractual obligations. They also question Melania's credibility, highlighting potential personal incentives to cooperate. A partial gag order now prevents either side from making public statements that could prejudice the jury pool. Ivanka's legal team attempted an emergency appeal to relax restrictions, but it was denied. She cannot travel internationally, cannot speak publicly about the case, and cannot leave the Southern District of New York without court approval. The legal strategy now focuses heavily on procedural arguments and protecting evidentiary rights while preparing for the device surrender and status conferences. Experts note that this procedural battle is as critical as the substantive case. Former Assistant U.S. Attorney Daniel Goldman highlights that family testimony combined with device evidence could be decisive. But Caroline's policy warns that proving intent for structuring remains difficult. The prosecution must link devices to both knowledge of federal thresholds and deliberate effort to circumvent reporting. Legal precedent is on the line, both in terms of family witness testimony and the application of flight risk protocols via passport seizure. The timeline is tight. By Wednesday, devices must be surrendered and analyzed. The grand jury reconvenes. Thursday, February 12th, and additional charges could follow. Prosecution responses to defense motions are expected Monday, February 16th. Every day matters, and the speed of these developments underscores the intensity of the investigation. The courts, the prosecutors, and the defense are playing a high-stakes game where procedural maneuvers are as important as financial evidence. The procedural moves signal one thing clearly: prosecutors are confident and strategic. They are not reacting in real time. They are orchestrating a sequence that maximizes leverage. From seizing passports to unsealing exhibits to mandating device compliance, each step is designed to maintain control of the narrative and evidence. The defense, in turn, must counter with credibility challenges, procedural arguments, and alternative explanations for transactions. The Ivanka Trump case isn't just about a single family or individual. It has implications for financial oversight, legal precedent, and market behavior. Following Friday's arrest and the media coverage, Trump-affiliated stocks dropped 12%, and bond prices fell 8% by market close. Investors, particularly those in politically exposed businesses, are taking notice. Legal uncertainty carries real-world consequences. This case also sets new benchmarks for the use of family testimony. In federal investigations, spousal privilege protects married couples from forced testimony, but stepchildren have no such protection. Prosecutors can approach them, offer immunity, and use voluntary cooperation as evidence. That may influence future cases where insiders or family members have first-hand knowledge of corporate or personal financial activity. Legal analysts say the precedent is being written now, particularly regarding the combination of family testimony and structured financial activity. Meanwhile, the practical lesson extends beyond high-profile individuals. Anyone who has intentionally structured transactions to avoid federal reporting thresholds is now under scrutiny. Cash-heavy businesses, real estate investors, and small business owners could face enhanced enforcement. Experts advise reviewing transaction histories, documenting legitimate business purposes, and consulting financial advisors. The IRS has already increased enforcement on structuring by 340% since 2020. And Ivanka's case is the most high-profile example to date. The court schedule adds urgency. Wednesday, February 11th, device surrender and status conference. Thursday, February 12th, grand jury reconvenes. Friday, February 13th, devices analyzed, compliance deadline. Monday, February 16th, prosecution response to defense motions. Each date brings potential new charges, procedural shifts, or evidentiary revelations. The timeline compresses the typical pace of a federal investigation, signaling the seriousness with which prosecutors are proceeding. Beyond legal and financial concerns, the human element remains central. Melania's cooperation introduced a rare window into private family interactions. Whether her testimony holds up under scrutiny, whether the devices corroborate her statements, and whether intent can be conclusively proven will determine the next phase of this investigation. Every movement from structured withdrawals to offshore wire transfers now subject to forensic analysis. In short, the Ivanka Trump case is a high-profile, multidimensional legal battle. It combines financial evidence, family testimony, procedural maneuvers, and political context. The passport seizure, bond, gag order, and device surrender are more than procedural. They signal prosecutors' confidence, strategic planning, and expectation of additional evidence. The defense must navigate complex legal terrain while addressing credibility, intent, and legitimacy of business activities. The outcome is far from certain. Cases like this have collapsed before under political pressure, public scrutiny, or insufficient proof of intent. Yet the filings, the witness testimony, and the procedural steps suggest prosecutors are preparing aggressively. Investors, legal professionals, and business owners are watching closely. The next 2 weeks will reveal whether this case strengthens, whether it shifts, or whether it opens new avenues for both prosecution and defense strategy. The story is far from over.